dignitaries on the dais, dignitaries off the dais, distinguished guests, esteemed participants, ladies and gentlemen, a very good morning to all of you. It is with great pleasure and enthusiasm that I stand before you today to celebrate International Arbitration Day and to reflect upon the pivotal role that arbitration has played not only in India but at a global stage. As we gather here to commemorate this significant occasion, we are reminded of the enduring importance of arbitration as a means to resolve disputes, promote trade, and foster economic growth worldwide. This day serves as a beacon guiding us through the complex world of cross-border disputes and peaceful resolution they demand. India, with its rich history and diverse legal landscape, has been both a beneficiary and a contributor to the global arbitration community. Over the years, arbitration has played an indispensable role in India's development and its integration into global economy. The Indian judiciary's pro-arbitration stance and the legislative framework, most notably the Arbitration and Conciliation Act 1996 and the recent amendments to the Act, have fostered a conducive environment for arbitration to flourish. On the global stage, the role of arbitration cannot be overstated. In a world marked by geopolitical tensions and economic uncertainties, arbitration provides a vital mechanism for peaceful dispute resolution. It transcends borders, cultures, and legal systems, allowing parties to engage in a civilized dialogue rather than resorting to costly litigation or conflict. International conventions and treaties have continued to facilitate the enforcement of arbitral awards across borders, enhancing the attractiveness of arbitration as a global dispute resolution mechanism. Arbitration decisions have contributed to the development of international law and establishment of legal precedents that guide future disputes. This has enhanced legal predictability in dispute resolution and has introduced stability in global trade. While we celebrate the recent achievements made in the field of arbitration, we must also acknowledge the challenges in arbitration becoming a favorable method of dispute resolution. International arbitration cases are of complex nature involving multiple parties, cross-border issues and technical subject matters. The demand for experienced arbitrators often outstrips the supply and leads to concerns about availability of arbitrators, conflicts of interest, and need to expand the pool of qualified arbitrators to meet the diverse needs. While arbitration is generally seen as more cost-effective than litigation, it can still become expensive, particularly in lengthy or complex cases. The arbitral awards are generally enforceable across the borders. However, challenges may arise when enforcing the awards in certain jurisdictions. Some countries may resist recognizing or enforcing foreign arbitral awards, leading to protracted enforcement proceedings. Calls for greater transparency in arbitration proceedings, particularly in cases involving public interest, that is, investment disputes or environmental matters, raise questions about how to balance transparency with the confidentiality traditionally associated with arbitration. The technology has facilitated remote arbitration proceedings. It has also raised concern about cybersecurity, data privacy, and potential for technical issues during virtual hearings. These challenges highlight the need for ongoing adaptation, innovation, and reform in international arbitration to address emerging issues while preserving its core principles of neutrality, enforceability, and efficiency. Arbitration institutions, practitioners, and policymakers are actively working to find solutions and ensure that international arbitration remains an effective and trusted means of resolving global disputes. Let us today reiterate our commitment to upholding principles of arbitration, that is fairness, neutrality, efficiency, and enforceability. Let us also recognize the need for continuous innovation and improvement in arbitration processes, embracing technology, and promoting diversity and inclusivity within the arbitration community. In conclusion, I would state that today's celebration is the cornerstone of global diplomacy and economic growth. It is a testament to our shared belief in the power of dialogue and peaceful dispute resolution. As we move forward, let us champion arbitration as a means to build bridges, promote justice, and strengthen the bonds of cooperation amongst nations. Thank you.